Good evening, folks. I see people joining, so I'll just give it another minute or two to let everybody get in, and then we'll get started. Okay, I just see more people joining, so we'll give it another 30 or 45 seconds, and then we'll get started here. Okay, thanks for joining us tonight. Introductions. My name is Orion Irvine. I'm the Regional Director of the Canadian Labour Congress here at in the Pacific region. I'd like to start off by acknowledging I'm on the unceded traditional territory of the Musqueam Nation here in South Vancouver, and I invite all the participants to take a moment to consider whose land they are sitting on right now. So we have a great panel tonight. We have two guest speakers that are going to talk about long-term disability plans. And part of it will be unions' rights and responsibilities. So how it comes to represent members, kind of their duties, and also what rights they have when working with the employer on LTD plans, both setting it up on the front end, some of the stuff to think about, but also when they're assisting members in making claims. So we'll have two speakers that will go through a presentation on this topic, and then we'll have a chance for a text Q&A at the end. So if you do have a Q&A, just type in your question at the Q&A bubble, and then we'll get to them at the end. So without further ado, I'm going to start off with Chris Harris. Chris Harris is the director of the Income Security Division at the BC Teachers Federation. Before that, he was in charge of the BCTF's salary indemnity plan, which I'm not sure if he's going to go into much, but it's somewhat unique amongst the labor movement. So without further ado, I'll turn it over to Chris.
All right. I'm happy to be here. Thanks, Orion, for inviting me to deliver this information to people, because I'm just going to share my screen now. I just have a few slides that will make it easier when I go through some information. And if I do that, it's just because I'm in a building right now where, you know, it's automatic turn off the lights, and I have to wave my arm to make it come back to life. So there you are. Just share my screen here. And so I'm hoping that you can confirm that you can see that. I hope is I get a thumbs up from. Okay, perfect. Okay, awesome. So I'm just got a few slides here on advocating for members on long-term disability. When Orion first approached me, said that you know, he's experienced and other people are experiencing some issues when they have members that are going on to long-term disability plans, and how effectively you can actually advocate for those members, and what are your rights and what are your responsibilities. So I'm going to give hopefully some information there that will be helpful. And I just wanted, let me just see here. I got to make sure I can still go forward with, there we go. So just wanted to go over my background a little bit, just so you know where I'm coming from. I started off my career as a Vancouver elementary teacher, but I quickly became a staff rep at my school, and so spent many years as kind of that first contact when a member has a problem. I moved on after a number of years of teaching and filling that kind of shop steward role that we call staff reps in schools, and moved on to like bigger pieces in the union, becoming a local representative, and then eventually becoming the local president of the Vancouver Elementary School Teachers Association. And then through that is where I really became interested and involved in what we call our salary indemnity plan. And that's a plan that the BCTF has where we cover all members for long-term and short-term disability. So I went on that committee with the frame of mind that I wanted to make sure that our long-term disability and short-term disability plan was meeting our members' needs, but it was also treating members in a fair and equitable way. So there was a number of concerns I had at that time, and how we were adjudicating claims and how we were dealing with certain individuals depending upon what their specific disability was. So I became involved in that time, and I spent many years on the BCTF Income Security Committee before actually becoming and getting a full-time position at the BCTF as actually the plan administrator for our long-term disability plan and short-term disability plan. After I spent a few years doing that before I moved on to a different position where I would be helping out groups of locals in different parts of the province deal with labor relations and arbitration help. And then now what I'm doing is I've moved back to kind of where I was when I was the plan administrator. So now I'm back in as a director of the division where we do WCB advocacy and health and safety, and also run a disability plan. So that's kind of where we're kind of unique. So I just want to kind of make sure you knew where my background was, because yeah, you know, if as a union person and you get that phone call around someone having difficulty with their benefits or long-term disability and they really need some help and information, and they want the union to intercede. I've been there. I understand how difficult that could be, specifically when you don't have all the information that you need. So hopefully I can point you in some direction. And I know that Dave's following me, might be able to speak to some bigger issues around bargaining and things like that. So just go forward to our context and what our plan looks like. So the BCTF Salary Indemnity Plan is a self-funded disability plan that covers all regular contract teachers and associated professionals of British Columbia. And so we operate both a short and long-term benefits to teachers who, due to illness or injury, are disabled from working and have exhausted all of their sick leave. If the illness is work-related, we require them to file a WCB claim. And so what's kind of unique about this is we're not insured by any insurance company. We run our program, we're self-funded, and we have a salary indemnity fund that members pay into that we use for administration of the plan as well as paying benefits. We have in our division up here 9 case managers and a supervisor who fully adjudicate our short-term plan, and they receive direction from our plan administrator in that adjudication. And for long-term, we have Canada Life adjudicate our long-term claims on an administrative services only contract. And we still have ownership of the whole plan, and the plan administrator does make decisions. We do also have an income security committee that hears appeals and on the short-term side, and also makes decisions about what fee we're going to charge members year to year that will get sent to our annual general meeting. So our plan is run by regulations that are enacted by the BCTF annual general meeting. And so any of our regulations can be changed by the will of the membership with a 75% special resolution at the AGM. So that's kind of how we're unique. We're not completely unique in Canada. There are lots of different teacher disability plans across the country, and we regularly meet with the people running those disability plans every year. And I could say Manitoba is probably the most like us when it comes to teacher disability plans. So that's kind of where we are, and that's kind of, you know, and you might be different because very much so you may very likely, your only connection to a disability plan is one that is supplied by the employer. So you may or may not have provisions in your collective agreement that kind of specify what that disability plan looks like or what the employer needs to supply. But often I understand and I know that employers will either go out through mostly through an insured plan and get long-term disability benefits to their employees for a certain cost. But when someone gets sick and then goes onto that plan, a lot of times employers are just hands off. Okay, well, we've done what we've had to do for the collective agreement. We've supplied this plan. It's now up to whatever insurance company is adjudicating that plan to, decide on whether benefits can be paid or not paid for their policies. So that's mostly what I think most people run up to, but there's everything in between. So I would, one thing I think that's important for everyone to know that is dealing with members that are not well is that LTD is only one part of the timeline of disability. So one of the things that I say a lot is that, most of us will become disabled at some point in our lives to a degree that will impact the way we live. And so the average age of disability is actually 63 years old. So some people get there earlier, and then some people get there much later. But most people, that do end up being able to live a long life will get disabled in some way that will, dramatically affect how you live your life. So first of all, when somebody gets disabled or sick, they're likely to go on paid sick leave. They'll, maybe go on workers' compensation. There may be a combination of that depending on your collective agreement. How that looks like is usually dictated by the collective agreement around who does WCB pay, how does that work out. Then there's always, you might always have people go on EI sickness benefits, right? That people have access to for up to 15 weeks. Or there might be a short-term disability part to your plan. I think that is not everyone's plan has a short-term disability component. I think most don't. So a lot of people do go on that EI or sickness benefits prior to actually going on short-term disability. And then you're on long-term disability, and that can mean a lot of different things, right? And the length of time that people are on is dependent upon, what their prognosis is. Interesting, like if you have somebody that's gone on to long-term disability for 2 years or more, there's very few, like the percentages of how many people actually get back to work after that length of time is fairly low, like in the range of 5%. So it is kind of, there's this period of time of long-term disability that most insurance companies and adjudicators are really assessing the claim to see to what degree this person can go back to work. So either you go back to work or you remain on LTD until, a time where either there'll be a change of definition, and I'll talk about that in a sec, or that you're terminated from the claim because you've hit that retirement piece where you can take your pension, or that you age out of the plan where there's an age that you're no longer eligible for benefit, or unfortunately you die while you're on long-term disability. So the important part of, and kind of what your responsibility, I believe, as a union is that you should know what your plan design is, right? So it's really important for union officers and advocates to really understand what the disability plan that your members and most likely yourself are on, so that if there are issues or problems that you can practically answer their questions and hopefully intercede with the people that you need to talk to in case there is a problem. Oftentimes members need kind of some basic help, things like filling out forms. Remember, when people are on disability, there's a reason, and there may have cognitive difficulties. They might have issues really understanding what's going on, and they might need some assistance in just doing some basics to make sure that they're getting what the plan needs, what the adjudicators needs to actually pay benefit. I know when I was the local Vesta president, we had somebody that was in the office one day a week, and they were doing other work too. But one of the things that we kind of gave to them in their portfolio was that if there was anybody that needed help filling out these types of forms, that they could actually come into the office and sit down with them and help them fill out forms. So that was like a valuable thing, I think, for not everyone, but for certain people that may not have family or friends that could help them do that. So things that you should know about your LTD plan. So this is kind of where, what is it that you're kind of, in my view, kind of responsible to kind of know, and how do you help people? And the first step is kind of, well, you've got to know your plan. So number one, who administers that plan, right? So in general, it'll be some sort of insurance company, right? Like Canada Life or BC Life or Manulife, or some sort of insurance company that will have adjudicators who will take a look at claims and make decisions. So you really have to make sure that you know who it is. A lot of people will think, oh, that's my employer. My employer administers the plan. Well, they set up the plan. They have a contract with an insurance company to actually adjudicate. So really the people that are actually making the decisions on a claim are the insurance company. Although there are big cases out there that you can probably read about that, where you see that actually, oh yeah, the employer kind of interfered with that adjudication because of their negative view of their employee, perhaps. Especially, I would say that was probably more common 10 or 15 years ago, where there still wasn't a great understanding of mental health claims, and oftentimes those labor relations issues, were the main cause of them was because of mental health. So it's important, though, that you kind of know that who actually you need to talk to there. So also, who is eligible, right? So you may have members that are different categories. You might have casual workers. You might have people on term contracts or continuing employees in your bargaining unit. It's really important to know who's eligible. So for instance, for teachers, you have to be a regular contract teacher, which means you have to be on a term contract or a continuing contract. TTOCs don't pay into the plan, and they're not eligible for benefit. So generally, you're eligible if you're paying into the plan, then you'd be eligible. Some plans allow you to continue to be eligible if your member's on a leave of absence, and generally those give you an option to continue to pay for that premium costs there in order to be eligible. So that's something that's really important, because if you've got members that think they're eligible but they're not, that can be an issue. Then when is the qualifying period? So the qualifying period is like, what effectively is the time where if you get disabled, that you're going to have coverage. And so at times there's clauses in the policies and regulations of disability plans where, the first 20 days of employment that you're not eligible, right? So that's an important piece of when you have to know what this qualifying period is, and so that so you may even have people paying into a plan but not be part of that qualifying period. So that's important for you to know. Just like if you get sick over the summer and you're a teacher, you're going now, and the second part is that the effective date of coverage. So you qualify for benefit, but the effective date of coverage would be the first day back to work. And so that would be in September, right? So those are two important pieces to know. Then the other one is that is, I think, the crucial part, which is, I think, one of the more concerning things for claimants is around the proof of the claim. So I think a lot of people kind of view long-term disability on the outset as the same thing as sick leave with your employer. It's very different. Okay, so your employer doesn't have to actually even get a sick note to put you on sick leave, right? Like, they can put you on sick leave. They have a great ability to do that. Now, that doesn't mean that they will. It just means that, legally speaking, they have a ability to do that in the absence of information. However, that's not the same when you're dealing with a disability plan and the high bar that's there in order to prove disability. So So what is the proof that you're required? Is it, is there forms? Is it, is it a medical doctor that you need? Is it do they need specialist information depending upon the type of disability? So this is kind of the really important piece. It may be that that proof gets higher as time goes on, where initially you'll just need a GP to fill out a form and get benefit. But as time goes on, and if they're, specifically, such as if you're a mental, if your disability is a mental illness under the DSM-5, they might require you to see someone like a registered psychologist or psychiatrist in order to get continued benefit after a certain point. It's really important that you kind of understand what they require, because oftentimes members get very confused about what it is that's required and don't understand why this is different than sick leave. So, the forms are actually really important. And what I would suggest, you go to the employer. If you don't have those forms, if you don't know what they look like, you can ask for those forms and get them. Should be no reason why those forms are kept for you. So that's one of the things I recommend all unions to do, is make sure that they have a copy of those forms in their office so they know what it looks like. There's no surprises. And if there's questions or concerns about those forms, like, don't wait until you have a member who's now a claimant under that plan, and now you have an issue with the forms. It's important to get them, and if you need to put them to legal counsel if you believe that there's issues with those forms. So what is a definition of disability? So that is generally the big question, right? When it comes to, is this person going to qualify or not? So in general, most plans are not preventative. And that's why during this time of COVID-19, you'll see that people that say, well, I have an autoimmune disorder. I can't, if I get COVID-19, it's not gonna be good for me, so I can't go to work. Do I qualify for long-term disability benefits? So I could tell you, just like most plans, our plan here is, no, you actually have to be injured or ill. It's not a preventative plan. And so, that's the case in most disability plans. So it can't be for preventative reasons. So in general, there will be a period of long-term disability that you have to show that you're disabled from your regular job, so your own occupation. But there will become a point, anywhere from 12 months to 2 years, that somewhere in that range, that you're going to have a different definition that you'll have to overcome. And there'll be, any occupation that you're disabled from. In general, there's generally a gainful employment clause that's married to that, any occupation time. And so that could be 60% or some 50%, somewhere around there, around, to what degree does this person have an ability to go out and make an income now with the level of illness or injury that they have right now. So that's a big clause, and that's often where you'll see members have issues with disability plans when they're adjudicating this piece of the plan and the claimant's file. So it's important to know what that gainful employment clause is, as well as to, when's the time frame that they're going to have to go from what we call ONOC to NEOC. The other parts that are important is, what is the benefit? So what percentage of benefit is this so our plan is a little bit unique in the sense that our benefit is, because members are paying into it with their own money, and we're investing that money, and then they're receiving it back, that we're actually it's a tax-free benefit. But in general, especially with insured plans, your benefit is most likely to be taxable. But it's important to know what that percentage is and how it's what it means. There might be levels. It might be a certain percentage for the first 40,000, and then a second percentage for the next 40,000, and then something different above that. So it's really important to know that what the benefit is, because members will be like, this isn't my salary, and it won't be. Generally, it will be something less. Disability benefits are generally not meant to be salary replacement, but actually meant to be something to give some financial it's like a safety net. Other parts is their offsets. So, if you're on WorkSafe, if you've got a WorkSafe claim, or you're get money back because you were in an accident and you're get money back from ICBC, for instance, are those monies that are going to be considered offset to those benefits, so that money gets clawed back from the benefit because you got money because of that injury from somewhere else. Those are very important things to know. What are the rules about accommodation employment? And what I mean by that is like working part-time. Different plans will have different rules about working part-time that will also fit in after a certain amount of point of gainful employment. So for our plan for teachers, it's 60%. So if you go past a certain point and then you're now into your NEOC and you're able to hit the 60%, well, you're done on disability. That 60% is now is what you're able to do, and that's going to be what your salary. You're not eligible for benefit after that point. What are the duration of benefits? Like, when do benefits go to? Is it to 65? Is it to full pension? Is it, when do those duration of benefits go? Another thing to know about your plan in that regard is what happens to someone's pension when they go on to long-term disability. Is the employer still making payments into a pension plan? Are those pension plan payments, have they been waived by the pension plan? There's lots of different arrangements that can happen there, but generally that's important to know, because once a person's off long-term disability, they're going to rely upon generally a pension in order for the rest of their life. Then there's, what are the timelines and appeal mechanisms? So, lots of claims don't have problems. The disability is well known. There's good medical. They go through it. They might need a bit of your help with understanding what the plan is. They might need some assistance in filling out forms, but there's no kind of big issues about them getting cut off. But sometimes there are those issues, especially when people have illnesses such as substance abuse disorder, where they might start using again. I think generally all plans have some requirement that you follow your doctor's treatment plan, and those are requirements under the rules and regulations and policies of plans. And so people can get cut off. They can get suspended, they can get cut off, and it's important to know what the timelines and appeal mechanisms are. Now, I know you'll probably see commercials on TV about never appeal and don't trust them. However, what I could say is, like, there is oftentimes when what the adjudicators need is just additional medical. So the medical they have didn't fully explain it. Some doctors don't do a good job filling out those forms or fully explaining what is going on with a person. So it's, submitting additional medical is often a first step in kind of an appeal. And oftentimes, and I see that a lot, that the member gets put back on benefit just because they were able to submit medical that was sufficient. Is there subrogation? So subrogation means, again, very much like what I discussed before about offsets, but subrogation is a little bit different in the sense that it's more of those ICBC claims where that person gets a big chunk of money for the past, and then this plan has been paying maybe $4,000 a month, depending upon how much what the salary of this member is and what the benefit is. If that big chunk of money was meant to pay for salary, right, for a period of time, there might be a subrogation agreement that members are forced to sign in order to receive benefits, and they will go after that money. So that's important to know. And then, is there a mandatory rehabilitation program? So, lots of plans do have some sort of mandatory rehab. Some of it can be a real benefit, like getting you into diagnostic treatment earlier, just like WorkSafe does, or ICBC, in the sense that they will have, rehab consultants who take a look at what's going on with somebody and may be able to get MRIs or CT scans or some other type of occupational, therapy in order for somebody to get better physiotherapy. It's really important to know if these are mandatory or voluntary programs, because members need to know that. They need to know like what could threaten to cut off their benefits and what they can say no to. So, everyone, that's part of a union and has members on a disability plan, they do have a duty to represent their members as per the BC Labor Relations Code. And so I think what your main duty is to know what your disability is and its connection to the collective agreement, right? So that's an important piece. Generally, as part of your collective agreement, you may have under benefits a disability plan that the employer has to supply, and they have to be doing that in a good faith way. So if there's some shenanigans or issues with somebody getting on to disability, by all means, like, you can take on employers if they're not meeting their collective agreement responsibilities there. But also you need to know like what that relationship is. So one, it's always good to get the actual, if you can, and I always suggest, like, when you're actually bargaining is always the best time that you can request information. And it's really difficult, for employers to say no at that point. So it's always a good point to get the contracts that they have with any type of disability insurance company, so you can really read the fine print. The fine print makes a big difference. So you're able to get that. So then that's where you need to kind of, as best as you can, no one's expecting anyone to be an expert, but you kind of need to know what the rules, regulations, and policy of the disability plan, or where you can look them up. And because it's, there will be times where members need that kind of specific information. And then, it's a good idea to know who to talk to when issues arise. So that's a conversation that I think that every union should have with their employer. Hey, listen, if my member has a problem with their long-term disability plan, who does the union talk to? Who is it that I can get some assistance with so I can assist my member? I know a lot of time the insurance program, like insurance companies, just refuse to talk to the union, right? So your way in often is through the employer so that you can help. And it's a good idea for, for you to talk to your employer right up front before any problems happen, that you can tell them, it's like, listen, if there is issues with long-term disability plan, how can I help my member? Where can I get information? Where can I find out what they need? And there might be waivers that long-term plans have in order to, have unions that members sign, just like they would, like lawyers do, so that they can get the necessary information to help members. It's really hard to help somebody if you don't know the whole situation, though, right? So members that come and they don't want you to know their situation, it's very difficult to kind of intercede when, what you'll hear back is, well, we have all their medical, we have the chart notes, we have everything we need to see, and we can tell you right now that they don't meet the definition of disability. So it's really important to know, well, who do I talk to about this? What can I find out? What's missing? Then, like I said before, know what the appeal procedures are. I think that if the appeal procedures are sometimes kind of hidden from people, you need to kind of expose those and use those as best you can. I think when you go to arbitrations and to suits, that when you can show that you've used all the mechanisms under your control, that's always a good thing. And then, of course, when things are big, or you need the help, by all means consult legal counsel when necessary. Don't forget, it's like, listen, if you've got members who are disabled, and they can't go to work, and now they're being cut off long-term disability, and you've done your due diligence and you really think this person's disabled, you might need some help from legal counsel. So just to finish up, because I know I'm probably running into my time here, my general advice here is, number one, providing medical is not always a bad thing. So I know that oftentimes people don't want to provide all their medical, but listen, it's my experience that the more medical that you actually give, the bigger chance that they'll see the disability, right? That they'll find the points. Now, that's not always to say there's not contrary information in there. It's always great when that medical is consistent and you don't have one doctor saying something different than another doctor. But don't be scared of providing, saying, hey, listen, can we provide different medical? Oftentimes, the first thing a lawyer is going to do is say, okay, let's get this person to an independent medical exam, because that's going to do wonders for us to prove disability. And sometimes those medical exams come back with not such great information. But it's like, don't be afraid of actually supplying it if you need it. There's a hierarchy of medical, is my other advice, right? So, oftentimes people don't understand about that their own doctor, their GP, and the doctor saying, yeah, you can't work, but the insurance company is saying something different, and you get some specialist information. That specialist information is going to be looked at different than a GP, and it's going to have a lot more weight to it. So just so you know that the specialist information is always kind of the most important. Rehab consultants can be very helpful. If you have rehab consultants that are available to your members, I would suggest that you always use them, because when a member goes into the doctor, doctors don't necessarily aren't very necessarily great return to work doctors. They don't necessarily know everything about specific things. Like, most doctors actually don't know what the work of a teacher is. They think they know, but they really don't have a full understanding. And so when we can send rehab consultants with our members into the doctor's office to kind of explain what's going on, the doctor has a great understanding and is able to fill out the disability forms, as well as help with accommodation processes when there's return to work as well, a lot better. So they can be very helpful. One thing I always kind of advise around, especially around these things when you're trying to help members, is that, help with the process, but don't promise an outcome. We're not doctors, so we can't. So what our opinion is on their health isn't going to be looked at. It's going to be dependent upon the medical profession. And there's disabilities out there that are still hard to figure out. And I think of a couple on the top of my head that aren't even accepted, right? And so that's tough, and it might be out of your control to really change the narrative here for members. So, but promise, help them with the process, help them with the information, help intercede as best you can with who you can intercede with, and then that's the best you can do. And then, like I said, in difficult cases, get some help, and that often is legal counsel. So I guess that's kind of it, but I'll hand it off to Dave to take over, and I think we're going to do questions after. So I'm going to stop my sharing here.
Thanks a lot, Chris. So that's right. So if you have questions, please throw it in the Q&A, and we'll be able to address them at the end. So next up is Dave Porteous. Dave Porteous is, sorry, I can't remember your title at WE Consultant. You're the president of WE Consultants and Benefit Services, who helps unions basically write and negotiate their benefit plans. More importantly, however, he is one of the founding members of the South Okanagan or North Okanagan Labor Council. Can't remember which one. So he's a long-time union activist, not just an insurance guy. So Dave has a 15 or so minute presentation about some of the things to think about when you are looking at a plan. So over to you, Dave.
Thank you. I'd like to thank the CLC and Orion for the opportunity to discuss disability issues. We actually look after some of the biggest union trusts in Canada, and we administer one of the biggest standalone LTD programs for unions in Western Canada. I did send a document to the CLC to Orion. It's called a disability roadmap. And I didn't want to go through that this evening because it's, even though it's only 15 slides, it's actually how to roll through a start of a disability claim to the end. And it was designed for union reps or anyone working on disability claims with their members. And it's from start right through to graduated return to work. So if anyone wants a copy of that, you can either, I guess, email myself or Orion, and we'll get you a copy of that. It is used by quite a few unions and has been very successful. So what I'm going to go through is some of the questions that we get asked all the time by unions, and it seems to the same questions keep popping up. So I'm going to start off with like, how do you pick a good disability provider? We get asked this quite often. And first off, I should tell you that there's very little competition left in the insurance industry. When I started in the industry in the 80s, I worked for a national insurance company. There was about 85 actual insurance companies that dealt with disability in a big way. Currently in Canada, there's only about 8. So it's become like the gas and oil industry. It's narrowed down. They keep getting swallowed or gobbled up. For instance, there's 2 mutual fund companies left, mutual life insurance companies that do disability out of probably about 20 companies left. There used to be over 20 mutual companies, and the difference between a mutual insurance company and a regular insurance company is one is for profit and the other actually shares the profits with their stakeholders, which are the members that are covered under the plan. So anyway, how do you pick one? Well, the only way I could describe how to pick a disability provider is service, product, and price. Service, it can be various items, claims procedures, clear wordings on eligibility, fast turnaround on claims approvals. Do you have a designating union rep and or LTD consultant authorized by your union to help and submit claims and disabilities, on disabilities? And including appeals, by the way. We do quite a few appeals for union members, and it's becoming a serious problem. And back to the statement that you heard earlier, you'll notice that the lawyers are advertising like mad on TV to get you signed up on any kind of a disability claim. And they will take sometimes 40% or higher of your disability money if you're successful. We've been doing that literally for free for the last 25 years. So don't get wound up with some of these lawyers unless your claim goes sideways. We have recommended on a few cases, we usually get about 1 a year, where we'll recommend that legal counsel be brought in to get it satisfied. And the next comment is policy wordings. I talked about clear wordings on eligibility. Policy wordings are one of the most important thing under any kind of coverage, whether it be disability or any other part of a benefit plan. There's 3 items. If you think of disability, there's the coverage of disability, then there's the limits you have on the disability, what maybe your entitlements are. But the big one that everyone forgets is the policy wordings that really describe if, how, and when you might get paid. And for the last decade, this has become the #1 issue. Insurance companies are constantly changing their policy wordings to make sure that claims do not get paid or slow down the process and people go away eventually. Product's a hard one. It really is, what's the structure of the LTD coverage? Can your members live on that amount? So one thing we find is a lot of LTD plans do not have COLA clauses, cost of living clauses. And if you have a member that's young that goes on disability for 20 years, even longer, believe me, that money becomes very scarce and it's very hard to live on it. The other thing is wordings like within its own job versus own occupation. We don't see a lot of own jobs anymore. That used to be, there used to be a lot out there. And it's really important on an LTD claim. Own job means exactly the job you have. Own occupation means doing the job you do, but it could be with any employer, not necessarily the one you're working for. So there's a huge difference there. It is a cost factor, but it is something you may want to look for if you're looking for improvements on your current LTD plan, if you're fortunate to have one. The waiting periods is another issue. There's also the 2-year own occupation. When I started in the industry working for a national insurance company, all disability went to age 65. There was no 2-year own occ. This was a way brought in by plan sponsors, who are about 80% of them are employers in Canada, unless you're under a trust or it's a union-run program. The plan sponsors are the ones that are totally in control, and that has created a problem where they keep adding these new wordings like own occupation. I've even seen some collective agreements where they're down to 18 months for own occupation versus 2 years. What you have to understand is 2 years means after 1 year, the insurance company is going to try to get you into another job. They're going to try to get you off claim. If it's a 18-month one, that'll happen with 6 to 8 months. They're going to try to get you off claim or sooner. Price, well, employers buy disability usually based on price. And the sad thing is most employers are ignorant to the fact that every insurance company out there that writes LTD, they eventually want to get that client, meaning them, the plan sponsor, they want to get them to what they call manual rates. So unless it's a union-run program or a program that's pooled through somebody that works for the unions, what happens is those rates will go up every year for usually a 4-year cycle to get to manual rates. Manual rates are usually the highest rate in that type of industry. So we find on average 65% of every renewal that goes out to an employer is done improperly and they're overcharging on, and LTD is no exception from that rule. The other thing I talked about is who controls the policy. The plan sponsor is the one that controls it, and I really recommend every union and local out there has got to try to get control of their benefits. There are different ways of doing it. You can do it through a collective agreement. You can do it by possibly either a union trust or a joint trustee plan, we have started this about 10 years ago, is a wording called a joint agent of record. I won't go into detail on that, but what it does is allows you to hire somebody licensed to look at these documents and all the data annually, and the employer, of course, has to agree, so it's usually written into the collective agreement. But that wording, joint agent of record or agent of record as it's called under the Insurance Act, is something that does stand up, and they have to give all of the data. And that leads to the thing and we find this a lot, that a lot of unions and locals are having trouble getting the copies of the claims data, copies of the annual reviews on an annual basis. You have entitlements under the labor code to get this, and the minute an employer makes one comment during bargaining about cost of benefits going up so they can't afford to do whatever, that opens the door up massively for you to get every bit of information. Remember that benefits are remuneration. If you never had benefits, you would have higher income. So when you hear an employer say to you that it's the employer's benefits, they pay for it, even if they're paying 100% of the benefits, that money is your money. It's been pre-negotiated years ago. It's not the employer's money. It's already designated to you, the individual member. Moving on, one of the other questions we get asked a lot is, how do we keep costs down? And I do get this from unions as well as the employers. We sit in on a multitude of collective agreements where locals bring us in to help them negotiate their benefits. And we have a lot of fun with it because it's amazing. Don't ever assume the employer knows more about the benefits than you do. We find that about 50% have a rough idea, and the other 50% either don't care, don't know, or they lie to you. So one of the things the employers will try to do is, one, they change the payout levels. They want to change the wordings, in other words, of what gets paid out. It could change the eligibility rules. In bargaining now, one of the biggest things we see is they want members to pay part or all of a premium. And they always seem to gravitate to LTD first. And the reason they do that is LTD is going up in cost because of things like COVID, and before that, there was other issues. What we've seen is spikes in LTD rates, and the future looks very, very poor in terms of trying to keep costs down in LTD. So structure is important. Cost is vitally important for your members, especially if it's a member-paid plan. So that leads to the next question we get asked a lot. Which is better, a member-paid plan or an employer-paid LTD program? Well, the real answer is you should always try to negotiate the employer to pay the benefits. If you can get the union to run the benefits, I always hesitate and say don't do that unless you can get ongoing funding for increases in the benefit costs built into your collective agreement. If you can do that, that's fine. But we really believe the employers should be paying 100%. And we also believe that members should not worry about whether it's taxable or non-taxable. That can be fixed in the percentage of payout, so it's equal to the same amount of money. Does your local, another point here, does a local have sick days, short-term disability? And are they coordinated with LTD? And the only reason I mention this is depending on what you have, a STIP program, they're called all kinds of things in front, or it could even be the government EI program. The thing you want to do if you have another program, especially if it's short-term disability or WI or sick days, you need a way to coordinate it so that the flow of information to the benefit, the LTD benefit claims adjudicator is there, because the flow of information is vital to make sure the member gets a check in a timely manner. One of the things we find is locals or unions phoning us saying, we've had this situation and our member is 3 months past their waiting period or elimination period, and they haven't got a check yet. Why would an insurance company do that? And it's because if they got all the medical information on the last day of the probationary or the elimination period, it means that it could take them 2 to 3 months before that claim's approved. So don't assume time is on your side. You need to get that information. And medical information on an LTD claim, if it's insured, you'll go nowhere unless you have proper documentation. And part of that document that I sent to the CLC as a handout will explain that and what is needed, and it's fairly detailed. One thing we do recommend not to do, and that is never, ever have a member or the physician's medical statements sent through an employer's computer or fax machines. Unless you have some internal wordings in your collective agreement regarding use of employers' equipment, that information that's sent through is information the employer can grab out of that system at any time. And it's confidentiality here. The employer should never see the information on the claims you're putting in. And quite bluntly, that even goes down to a dental claim. Under the Privacy Act, they should have all documents in somewhere where a member can grab them without going cap in hand to an HR department. Assessing your eligibility, Chris talked about this a bit. You really have to know your wording again, one in either the collective agreement or two, the insurance contract. Another reason you should have it to see, are you eligible and what is the criteria that either makes you eligible or not eligible? So again, the wordings are very important. Now, the other issue we get a lot of is members that they'll phone in on a disability claim and they'll phone us because all of a sudden they got cut off, say, gee, I got cut off, and we'll start asking questions, and usually it's they got a letter from the claims adjudicator stating they needed something, so the member would phone. The insurance carriers keep call logs. They document a call even if nothing is discussed. So they can tell if your phone number that you're phoning from has ever phoned in. So if they ever ask for information, you've got to reply or get a hold of them right away if you can't reply, but you have to do what they're saying. You can dispute some of it, possibly later, but if you want your claim, if you're in the middle of a claim, never ever say no. Say, yes, I'll get right on it. And if there's a time frame, you have to write that down and don't forget it, which leads to keep a diary. On a disability claim, you want a diary on every date, the times, when documents are submitted, anything you've been told to do, who told you to do it, what was the date, and what was the time frame that was going to happen in. That becomes vital, and it'll help you through your time of need. One of the areas that we've seen probably in the last 10 years more so, where people are getting cut off disability or denied disability have to do with social media platforms, Facebook, Instagram, Pinterest, etc. Anyone that's applying for benefits or actively receiving benefits, be aware that what you post could potentially jeopardize your disability claim. We actually have in that document as a handout an actual true case that happened, how somebody got cut off benefits. And I'll tell you, even employers now, before they hire people, are going on social media and it's stopping people from getting jobs. You've got to tell, especially your younger members, this is deadly information. And by all means, if you're on a disability claim, don't go putting on things where you're out actively doing things. They do look, and the bigger the claim, longer the claim, the more they search, including hiring investigators, including watching you at home or every time you go out. So then they start quizzing you, and the minute they find that you've lied to them once, your claim will be cut off. And that goes for every carrier out there. So it's not just related to one or the other. The next issue that's becoming a massive issue, and this is probably the most recent one in the last few years, is workplace-related issues. If there's a problem with a worker at work, could be because of middle management, it could be harassment in some kind of manner. What happens is the individual goes to their doctor, and the first time they're starting to get medication for stress or whatever, the doctor's writing in a workplace issue. Remember, on a disability claim, no matter who you're with, that medical information is accessible by the disability claims manager. It's the only way you'll ever get a disability claim. And if they see anything in the notes from that doctor relating to workplace issues, they will slow down your claim or ask you hundreds of questions more and start looking into it. And in some cases, we've even seen them approach the employer and start asking them questions. And that leads to really bad scenarios, as you can only imagine. Another issue that we run into a lot is disability benefits and the workers' compensation coordinated claims. We've had a lot of people say, oh, I'm not going to put in a disability claim because it's a workers' comp claim. Regardless of what caused the disability, submit a disability claim. This is very, very important. I'm not sure if it was in the document I sent out, but we actually had a situation about a year ago where somebody was on WCB for over 2 years, and the WCB asked for all the money back because they got disqualified. And if we hadn't put that claim in as a blank LTD claim with more info to follow, that claim would have not been paid out, and the individual would have been out over 2 years of salary they would have had to pay back. I won't go into detail on that because apparently there's been some further things happen on it. But which leads to the next thing. There's another reason to do that, whether it's a union paid plan or an employer paid plan. The minute you submit an LTD claim, then the plan, whoever's paying for it, no longer has to make those payments. Secondly, there's a life waiver in place. And I won't go into detail on life waivers, but every time you go on disability, they take a life waiver and they put it aside because it comes out of the other life insurance coverage under the plan. It's done a little differently. This is important for whoever's paying the life and whoever is looking after it. Members' responsibilities during a claim is the next one we get asked. A failure to comply with treatment. They will cut you off the minute you find out. One of the common things we hear is somebody says, well, I don't like the person, give me the treatment. Well, when you're at whatever that industry is, ask if somebody else could do it. If you're having a real problem, then get a hold of the claims adjudicator and ask a question if they could change. But never stop taking the treatment, whatever it is. You always have to be under the active care of an appropriate healthcare professional. Any delay in providing requested information or ignoring the dates for updates will likely cause a suspension of the claim. And I talked about this a bit before, but own job versus own occupation. Just so everyone knows, 25, 30 years ago, you could actually get disability up to age 65 without having a 2-year clause in it. They're all at the 2-year, but you really got to watch the wordings there, because why? You have to know what happens after the 2 years. And one thing we do tell most business reps or anyone that's working in claims for unions is you've got to have a discussion with the individual going off on disability and have a chat with them about personal finances. If you have an EPA program, if you have that covered under, they should have a long discussion with a person that knows what they're doing. The reason is they may end up living on a lot less salary than they have currently at their job. And I have had people where they've lost not only their homes, but their families. It creates marital breakups, partners separating. It's become a real problem if there's not adequate funds as a disability payment. And the appeal process, the only thing I could tell you under that, other than there is, again, in that document I sent to the CLC, a lot of information on the appeal, but it has to be new information, unreviewed, objective clinical evidence as possible. So even if you have to go out and go to other specialists that you haven't seen, it may be worth doing. And if you get a bad one, you don't have to submit that one. But if you get a good one, that's the one you submit. And you may not want to do that through your own doctor. You may want referrals from your own doctor, but you want to make sure that information doesn't flow back. And I say that, I'm not supposed to say that, but I would only send in the ones that would help you. And the final couple items here, graduated return to work, elements for a successful return to work. Very important to have somebody in your local or your union. And if not, you should get somebody to work with the employer to coordinate with the disability carrier and the employer. This is essential. And I say this, we had a claim once where it was actually the insurance company. We never saw the graduated return to work. The employer had sent in, phoned us and said, the employer's graduated return to work is designed to fail. And that happens all the time. They may want to get rid of that staff member. So you've got to make sure somebody's there making sure that graduated return to work is going to work. Also, we've seen cases where a person has worked days for 20 years. They do a graduated return to work on midnight shift. There are rules, and that one would probably not qualify. The other thing is disability exclusions and limitations. Very important to read this. It could be everything from pre-existing conditions, or it could be the policy or actual insurance policy wordings of what those restrictions could be. You've got to know this if you're a union representative or you're bargaining at all on long-term disability. So I'll end it with get control of your benefits. Get copies of the insurance and/or ASO contracts. And ASO contracts mean administration services only, because some plans are not insured. They're self-funded by the employer or a trust or other things. So I'll leave that for questions and I'll turn it back over to you.
Okay, great. Thank you very much. So we do have a couple of questions. So the next two kind of go hand in hand a little bit. So I'll read them both and then you can also kind of answer them maybe both at the same time. So What do you think the impact of COVID will have on long-term disability plans, and what should we do in bargaining about it? And kind of a follow-up kind of is stress leave and making a claim and some of the things around that. And I think with COVID coming up, we're seeing quite a few of our members are getting burnout and are starting to get quite stressed out. So kind of, again, impact of COVID, future of the plans, and also when it comes to stress leave, is there any specific tips and tricks on that? So maybe I'll, Chris, you first, if you have any thoughts, then over to Dave.
Yeah, so, in my talk to insurance companies at this point, they're quite concerned about the escalating costs that could happen because of COVID-19, although I don't see any direct evidence yet that that is being borne, right? So right now, where you have people, a lot of people in different sectors actually working from home, right? That might actually cause a less number of people to get sick and disabled. But that doesn't mean that that's a long-term thing, or that COVID-19 could very easily turn into something different. And I think that insurance companies right now are being very, very cautious around what they think the funding that they'll need and the premiums for future benefits. I think that there's a big belief that COVID-19 is actually going to cost more money in the end in different ways. But to say that we've seen that experience yet is maybe an overstatement. So when it comes to stress leave, oftentimes people are like, oh, I'm going on a stress leave. I would point out that stress is not a diagnosis, it's a symptom. So the important part with that is that you get people to doctors that can actually make a diagnosis, or in some cases a registered psychologist. So when you're dealing with stress, you're generally dealing with a mental health disorder, and so it's important that you are able to get like claimants or members can actually get to somebody that can make that diagnosis and prescribe treatment for that. So, the first thing that I would say is, if you've got members that are coming to you and they're very stressed and they're looking to take a leave, make sure you take a look in your collective agreement as to like when the employer will need some medical evidence, like a doctor's certificate, because it may be that they aren't required for 5, 6, even up to 10 days. So sometimes, a person has a little bit of breathing room there. They might not have a lot of sick leave, which is why they're coming to you. They really need at that point to get into a doctor to get a diagnosis. Not all doctors are great for mental health issues. And so that's why I would suggest that, going and seeing a registered psychologist, and oftentimes your extended health benefits will pay for a certain amount of visits, is a way to go. A caution to go directly to EFAP or EAP providers is that we find that a lot of them will, even if you are lucky to get a clinical counselor or a registered psychologist to sign, a lot of them will not fill out the paperwork. So it's really important to make sure that if you're, as soon as you're getting to a specialist, that those questions are asked, that, okay, will you fill out a disability form? And if the answer is no, it pays for you to go find another specialist or provider.
And EPA, so that's an employee and family assistance plan for those folks. Over to Dave.
Boy, this is a good one. First off, your collective agreement wording becomes vital here. So if you're coming up to any kind of negotiations, you've got to start looking at how that states. And the reason for that is we see a lot of collective agreements that have the word sick leave. Well, during COVID, sick leave, even though it was used a lot and maxed out, that's not the wordings that's needed. You need family leave days. And a prime example, Chris might be aware of this, is a lot of the children in schools. If you have staff that work for you that have children in schools, if they had the sniffles, the parent was phoned in the morning. I've actually had this happen internally, so I'm experienced on it. and the person has to leave and they can't take the child back for a few days. Most sick plans are not designed for that, especially if it's sick leave. You need family leave days. I know a lot of plans have some of each, but you've got to open up that wording so that during, and it could be just by adding things like COVID or other pandemics, create that's opened up and can be used for whatever it's needed for. The other thing is, other than EAP, the family assistance programs, paramed coverage becomes another vital area. You want to make sure that your paramed limits. You have to understand most policies and most of the wordings in them were designed in the 60s and 70s. None of them are up in the 21st century, I always say, unless they deal through us. But the reality is most are not. Probably 98% of the plans out there are outdated. Insurance companies are more reactive than proactive, and they don't want to change anything. But we all the time run into scenarios where people still have $300 for a paramed coverage, and I kind of chuckle, where they should have $700 or $1,000 in that type of coverage. So parameds become vital. The other area that needs to be rewritten, and this all relates to the insurance contracts, by the way, but you have to address it through bargaining, is short-term or WI. Your short-term coverage, again, even once it went to the 1 week waiting period on EI benefit from 2, a lot of short-term policies still state 2, by the way, or WI policies, and that has to be corrected under the collective agreement. But again, if you've got a 5-day waiting period, what happens if the person doesn't have sick days? And what's the speediest going to be the time frame to get medical information? Try to see a doctor. The time frame for seeing a specialist is sometimes up to 6 months. To see a doctor could be 10 days, 2 weeks, depending where you live. And is it good enough to get a nurse practitioner to sign it? In some parts of BC, there's not even doctors. So I highly recommend you've got to go back to that. With the question, we do have some medical staff or staff that have medical backgrounds. And from what we've been told, and including by some of the insurance companies, this pandemic is the first of more to come. And anyone that doesn't think that must have voted for Trump somehow in the US. Because the reality is we live in a society now where people are running around the world and they're catching diseases from all parts of the world and creating new ones. And because so many people have been on so many medications in the Western world for so long, it makes us susceptible to, there's no antibodies within our body to fight a lot of things now. So there's going to be always new medicines coming out, like the COVID vaccination. So don't take it lightly. It's really going to affect benefit costs. The insurance industries, I don't think they know. I think they're terrified, is how I'd put it.
Hey, thanks. And kind of a follow-up, we had a comment come through Q&A basically. And I think an interesting point is what happens if like a worker does get exposed to COVID at work? How does the LTD plan interface with WorkSafe and the WCB claim? And what happens if the insurer kind of refuses to follow the LTD because they feel it's a workplace exposure or COVID specifically, but kind of any injury? Have you had any experience with that, and kind of what's your advice?
Now,
go ahead, Chris.
Yeah. So, I mean, obviously, if you're sick, you're sick, right? And COVID-19 is an illness that would be, in my view, covered under a disability plan, depending upon all the stuff that we just said. But I mean, it's a legitimate illness. So if somebody catches is at work, my understanding and what, is it's compensatable, that you can make a claim, that there should be a claim. But just as Dave said, that it's also important that, if you do not have paid sick leave available to you, right, and you're you do need, you should be making a claim to the most appropriate thing, whether it be your short-term program, or possibly your long-term program at a certain point. when you're, it's important to do both at the same time. And and part of that is because the waivers that Dave talked about that are attached to long-term are very important. And so you often get access to that. So for example, for teachers, when they make a long-term claim, they get full pension credit for the teacher's pension plan through BC Pension Corp. So like it's a very, but if they just go on WorkSafe, they're not getting that. So there's certain kind of benefits to doing both. So that's very important. But I would say that there's been uneven experience when it comes to COVID exposures across Canada and across North America for sure. And one thing I would say is that there's a big difference between actually catching COVID and I haven't heard of any actual, when we're just talking about BC, WorkSafe, where somebody has caught COVID and put in a WorkSafe claim in our sector, anyone getting denied. We would fully support that person through our WCB advocacy program, and we would go down all the way down to WCAT in order to support somebody that was denied that actually caught COVID-19 during their working. Now it's like causation is like always one of those things. Did you actually catch it in the workplace? But I think our advice at this point is if you got a worker that catches COVID-19, you make a claim. So I don't know if I could say actually more than that. I mean, it's one of those things where there's uneven experience, and especially in BC, like where we've got, we haven't done terrible, in our experience with COVID-19. But that doesn't mean to say there hasn't been issues in some areas, obviously, like care homes and certain places in the province.
I would just end that by saying the first person that gets it at work, it's going to be very difficult to prove they got it at work. The second person, on the other hand, might have a claim. So I would go back to, I think it's important to submit claims everywhere you can, whether it be a WorkSafe claim, short-term disability to start with, and go from there. But don't hesitate to start the claim. They can only say no, but it may give you an avenue down the road.
Yeah, thanks for that. Question, this is probably more focused for you, Dave, but you mentioned, people trolling Twitter accounts and Facebook, social media, sending private investigators. Is there anything in privacy legislation that can help stop that, or do they mainly have free reign?
Oh, that's a great question. Do you know that when the Privacy Act came in, and I think it was 2001, the two things that had exclusions under the Privacy Act were insurance companies and banks. Okay, so that may answer some of your questions. Banks and insurance companies do share information. The other thing is anything that's on social media is not considered a privacy issue. If it's access to anyone, anything you put on, it's not just public information and they can use it. As for hiring investigators, they have that right to do it. They don't infringe on people. All they do is track what they're doing and document it. So there's no laws that I'm aware of that would stop that.
So I would just say that Dave's absolutely right. I can tell you, as I'm running, like we're running on in my department a disability plan, so it's very much insurance. And if there's fraud, that if there's suspected fraud, and there is a certain number of people that do commit fraud, and we go after that, right? So it's not fair to everyone else that's paying into this plan to allow people to fraudulently collect disability. And so, yeah, like all those tools that Dave talked about, looking at social media, sending out private investigators, are open to disability insurance companies to mitigate fraud. And obviously, one of the things that, I think it's important for unions to do is not defend the indefensible. So if there is somebody there that you feel that is not being truthful, be careful that you're not actually, arguing for somebody that is actually, you know, and there's been situations where we have people that, you know, are on disability that are out working another job, right? So those things, that's fraud. Like, you can't do that. And so you just be careful that you don't, and that's why I say it's always good to help people with the process without kind of promising any outcome or anything like that, because, you know, there are unfortunately individuals that do that.
Okay, thank you for that. So we're getting it almost an hour and a half now. So just one kind of last question is, what happens, I'm asking this as a member, like what happens if I prefer alternative healthcare as opposed to regular doctors, and how does that interact? I don't know which one of you want to take that on, but.
I'll try it first, only because it's when you say, is it like private healthcare versus not under MSP?
No, more like naturopaths and homeopathy and that sort of stuff.
Well, again, what we find, the paramed list that's on most insurance contracts that's been negotiated is usually only got about half the parameds that are out there, including what you just talked about. So it's back to the bargaining table and having those added. And I should tell you that most of the ones you're talking about are not that hard to get included, and they're very, there's no real big cost to them. There's 4 or 5 big parameds that are probably 60% of the total paramed costs. And I don't know what the last count was. We do have a list somewhere in our office that we hand out to unions, but there's probably about 22 or so parameds. It might even be more. So when you see most collective agreements or insurance contracts, they might have 10 or 12. So that has missed a lot, but this goes back to bargaining. A lot of unions, it's only been in the last, say, 10 years that unions have taken a serious interest in benefits. Now, why? Because the last 10 years is when the employers are trying to cut their benefits. And it always used to be handled as a secondary issue. It was always wages first, benefits second. Well, if you take any kind of survey with your members, and I always caution on that, you got to make sure you know what you're doing in terms of the survey, because you may hear stuff you don't want to hear. But the reality is, you've got to make sure that you're working for all of the members within that bargaining cert, and you get a bit of everything. And you've got to also make sure that the need is there. Like, there are things in every insurance contract that don't get used, and yet they cost money. So you've really got to know your own job site and your workers and the types of claims. For instance, in BC, the average worker now, I believe, is about 57 years old. But you may have a job site that has a lot of younger people, so it would make it cheaper for different things. And dental is a prime one on that. That makes a big difference. At the other, you may have a lot of one plan that doesn't have a lot of families, a lot of single people. It's a lot cheaper plan than one with a lot of families in it. And I say that because the older families get, the more there are people use it. Usually the single people are the younger people, and they don't put the claims in the same way. And one last comment I'll have on LTD. I saw the document, Chris, that had this age 63 for your average LTD claim. In some sectors, we've seen a drop in LTD claims at age 63, a big drop. And at first we couldn't figure out why. We thought, well, maybe they're just taking their pension early. But what we found out is, if a person has been off for a length of time, and they have a formula for their pension that says the last 5 years are the best 5 years of income, some are trying to get back to work to get it up. I highly recommend not to do that. I've seen situations where people come back and then they can't handle it and they can't do their job, and now they got a real problem.
Yeah, just to try to answer the question, because I think, like, they're interested, like, hey, you know, we have a member that, you know, doesn't really believe in Western medicine, or they believe in alternate forms of rehab or things like that. So my advice to that person is, find a licensed physician, you know, that supports you in that, right? And so, because you're going to need a licensed physician generally. In certain cases, disability plans will accept a nurse practitioner, and in some cases will accept a midwife for complications for pregnancy. However, what I would say is, like, if you are, you really believe in naturopathy or other alternate forms of medicine, that really what you need is to find a physician, a GP that supports you in using those sorts of treatments, but you'll be able to use him to sign the form and diagnose you, because those are the two things that you'll need from a licensed physician.
Okay. Well, thank you very much for your time. It was a great presentation. I found it very interesting. And as Chris mentioned, it's like, this is something that I deal with as the union president at the Canadian Labour Congress. So it's excellent to, it's nice when I can ask these questions and then get a full 90-minute answer for them. So it's wonderful. So I will email out both Chris's presentation and Dave's handout. Also, this was recorded and streamed on Facebook. So the video will stay up on Facebook and we'll post it on YouTube in a bit. So if you want to come back and watch it, we'll keep it available for at least a few months. And then we might take it down or we might leave it up as information changes. So once again, big thank you to Chris and Dave. I hope everybody enjoyed it, and big thank you to everybody who showed up today. And we have next week, I think this Wednesday night, we probably had to cancel it, but the following Wednesday, so not this Wednesday, but the following Wednesday, we're going to have Victory Square Law Office talk about COVID and employment law. So answer some of the questions that are coming up around kind of what medical evidence employers can demand. Can they demand a negative test? Vaccines, can employers demand vaccines? And all that sort of stuff. So please sign up to that. Same link that you used to sign up to this webinar, you can sign up to that one. And sorry, we had a couple people saying very good presentation. Thank you, brother. So thank you again, and have a good evening. And thanks for everybody for coming, and stay safe.